Good afternoon. My name is Amy Peterson. I'm the project associate with the Child Abuse Prosecution Project at the Association of Prosecuting Attorneys. APA is a private nonprofit located in Washington, D.C., serving prosecutors as well as their law enforcement and community partners. Thank you for joining our Final Friday Child Abuse Prosecution webinar today. Today's webinar, Corroborating Evidence Overview, Investigation and Prosecution of Child Abuse, will be presented by Bill Fulbright, County Attorney in Ravalli County, Montana. Today's presentation is made possible by a grant received from the Office of Justice Program through Office of Juvenile Justice and Delinquency Prevention. APA is very appreciative of their financial assistance and commitment to improving the justice system. By the conclusion of the webinar, you will be emailed a short electronic survey to complete regarding this webinar. The survey helps us to continue to provide quality training to you at no cost to your jurisdiction and assists in future planning for continuing legal education. We are in the process of receiving 1 credit of CLE certification from the state of Virginia for this program, and will email you your certificate when available in the days following this webinar. Please do not leave the webinar early, as we will use the attendee reports to verify attendance for CLE purposes. During today's webinar, you will be able to submit questions for our speaker using the question box on your GoToWebinar toolbar located on the right side of your screen. These questions will be forwarded to our speaker, and we will try to cover the issue during the live presentation. But be forewarned, there's a lot of material that will be covered today, and we may have to follow up with you via email following the webinar. If you need additional assistance, please feel free to contact us directly following the presentation. Today's presenter, Bill Fulbright, is elected County Attorney in Ravalli County, Montana. Sexual and physical abuse crimes against children comprise most of his prosecution caseload. He has worked with child sexual abuse victims testifying at as young as 4 years old, and has prosecuted child sexual abuse on behalf of victims as young as 7 weeks old. He is a founding member of the area's first multidisciplinary team, its Children's Advocacy Center, and the local CASA program. Bill is a nationally recognized expert and presenter, and trains prosecutors, law enforcement, and healthcare providers on investigating and prosecuting child abuse, and received Montana's 2007 Prosecutor of the Year recognition. I will now turn it over to our presenter, Bill Fulbright.
Thank you, Amy. It's good to be here with you this afternoon. We want to just kind of cover an overview. We can't go too in-depth in just an hour, but we want to cover an overview of the corroborating evidence issues when it comes to investigating and prosecuting child abuse. And one of the things that I've noticed over the years is that I end up telling juries that the crimes against children necessarily by their very nature are crimes of secrecy. But what a lot of people don't grasp is that in fact they're not abused in a vacuum. And so inexperienced or like inexperienced investigators may bring you a case and they talk in terms of proof. Well, we don't have proof of this. It's a he said, she said, and so forth. And we have to get out of that mode. We have to get out of the mode of thinking about the proof and think more in terms of what evidence do we have that corroborates the disclosures that we have, and focus our investigation and then our efforts with the jury on that. Corroborating, to validate, to support, to confirm, that's the type of things that we're looking at. So today we're going to spin through in very brief fashion just kind of a checklist, so to speak, that over the years I've developed in my brain, I guess, because when someone comes in to me and says, hey, I got this investigation going on, and here's where we are, these are the types of things that run through my mind of what are we looking for, what more do we need, where are we going with this, and as I approach a trial, that's what I think about teaching the jury. So the things we'll talk about briefly today in corroborating evidence: the disclosure process and prior consistent statements, this crime scene, the evidence I call opportunity evidence, tangible evidence, issues that arise with the victim, victimology or victim issues, victims' changes in behaviors, medical evidence, and then kind of more sophisticated, anticipating what the defendant's going to say. So to jump right into it, we talk about the disclosure process. Excuse me. At some point, when we know there's a disclosure, that means this case has gone from nobody knows about it to now we know. How did it get there? There is always, always, always a story there, something we need to know. And when investigators come in and talk to me now, they know I'm going to say, how do we know about this? What's that process? One of the reasons we want to know about that is because we need to corroborate everything surrounding that disclosure. For example, we have this young girl here who's disclosing in a forensic interview. Now, she's so young. At this forensic interview, she's 4 turning 5. She knows she told her mom. Beyond that, we have to go to mom to find out that, in fact, mom this child has a biological father who she has visitation with, and one day when they are having that visitation, mom gets a call from the Highway Patrol that says, hey, your daughter and your ex-husband were in a little crash. Everybody's okay, but he's asking if you could come pick her up early. It's when she got home, here's the picture of that vehicle actually. When they get home, mom, who happens to be a nurse, says, you know what, I want you not to sit in a bathtub, but because you were exposed to glass, I want you to take a shower. And they go into a big dramatic thing where the girl refuses to take a shower, and the disclosure comes because finally the mom, in exasperation, says, why won't you take a shower? And she tells us, the little girl looks at her and says, because of what daddy does to me in the shower. So of course, that process of disclosure, now we don't just rely on mom. We go find, in this case, it took a little while to get there, but we went back when we found out that story, and we found the crash from the Highway Patrol report. Here's a picture of the truck. The girl was sitting in that passenger seat right beneath the broken window, and if we zoom in on the seat itself, for example, there's broken glass. So mom's account suddenly has a lot of text and a lot of sense. Other times we learn about it more from the forensic interview from the child themselves. Have a case with a 10-year-old female. The teacher ended up calling 911 because there was a disclosure at school. When we dig into it and find out more, we find out from the 10-year-old that she actually had told a friend a few weeks before, a peer-age friend. Together with that friend, they went and told the friend's mom. Friend's mom, turns out, when we interviewed her, didn't know what to do, so she told the mom of the victim, who is, that mom unfortunately is supportive of the dad who's the perpetrator, so nothing happens. And a couple weeks later, during a meltdown at school, this 10-year-old ended up telling the teacher. But again, we have this whole sequence or process of disclosure that becomes important in explaining how we get to from not knowing to knowing. Helps corroborate this kid is, well, first of all, I should mention, a lot of times like that one, there are multiple disclosures. If we dig around, we find out they've told more than one person before they get to someone who knows what to do, who's able to do something about it. But there's always a compelling story. So we've got to go find out what that story is, and then have our investigators find it, and then we got to present it to the jury. The other thing is, when you do this, you help show this disclosure was, typically it's not calculated. The kid's not trying to do that. This wasn't generally the child's goal of letting the world know, isn't typically their goal. And typically it's a pretty traumatic event for the child. So this isn't something they're seeking out. And it helps the jury understand that this is something that happens often inadvertently, or that's how bad the abuse is, that they're seeking help. It just depends on the situation, but everybody's got a story, every one of them. In line with that, these typically fall into prior consistent statements, and this is the way I explain it to my investigators. Here's the crime, here's the trial time, we have trial testimony. Anything that that child said between those times is prior, it's consistent with their trial testimony, and it's by the victim, it's a prior consistent statement. So that's everybody they've disclosed to, people they've talked to at school, friends and family, maybe the interviewer, it just depends on the circumstances. Like I say, that story they've been talking about it somewhere. They've been telling people, because that's how we ultimately find out it's going on. For the investigators always preach, just find all those prior consistent statements. Everybody who's heard about it, we want to know about it, and then we can sort through them. Admissibility issues, typically you're looking at prior consistent statement being admissible under state law. You have to look at your own rules, of course, but in general terms, you're looking at a victim has testified and cross-examined, and the prior statement is consistent with that testimony, and somewhere in the process they've been accused of lying, fabricating, being coached, those sort of phrases. I've had this element upheld at opening statement, for example, where the defense attorney says, and this kid's not telling the truth, or implies that in some way. If they cross-examine them, implying that they've not told the truth. If we have to come back on rebuttal with it, we do that, but just get past that element. And then state by state, some states look at when or the timing of the motive to fabricate, and that may affect your admissibility on prior consistent statements. So just make sure you know where you are in your state as far as the admissibility of prior consistent statements. But I always push this envelope using 801, the non-hearsay prior consistent statements. Jumping to the next item, crime scene. Again, we have the inexperienced, the old school, so to speak, looks at it's just a crime that just happens. You always have to ask, where did it happen? That is a crime scene. Typically, it's not covered in blood like a homicide scene, so a lot of people discount it, but it's really important. When a kid discloses that, we had a little girl disclose that she was digitally penetrated, molested, while spending the night on a couch with her, I use air quotes, stepdad, and she describes the couch at this other person's house. We go to that house and we get a picture of the couch. Now the jury knows that this is where she was assaulted, and she can describe it even though she's young. Similar situation with another case where a girl described that her stepdad would sit on the bench in a shower that he had built, and that then while sitting on that bench, he would then, in the shower where she's in the shower, he would then molest her. And so when we go to that crime scene with a search warrant and take photographs and such, of course, we photograph the shower, and in fact has a place that an adult could sit. It just helps, it helps corroborate that statement that this was possible. That same case, actually, when the little girl was asked what about different circumstances, one of the things she said was that her half-brother often would visit the same weekend she was there. And when asked, she said her half-brother slept in her bed. Well, of course, that raises concerns, because now we have the issue of, is there another perpetrator? And when asked about, where she would sleep when her half-brother slept in the bed, she says, I slept in bed with Dad, which is one of the places she disclosed that the assaults had taken place. So when we further went through this house, we found this is the girl's room, and my initial question, of course, is everybody's going to say, well, what teenage boy is going to volunteer to sleep in the Winnie the Pooh room when he comes to visit Dad? That doesn't make any sense. But they take pictures of his room. Here's the teenage boy's room, of course. But what's missing in that room is there's no bed. And so the dad set up a situation. The half-brother, he needs to use the little girl's bedroom because there's no bed in this room. And the little girl, in fact, sleeps in Dad's room. Again, the crime scene just helps corroborate that this child is accurately reported. And it can be very, very simple. Picture of a bathroom. Is that dramatic? No, but it's very simple. When the girl disclosed at 8 years old, she was made by her uncle to sit on the toilet seat, or lid, I'm sorry, sit on the lid of the toilet and perform oral sex on him while he stood in front of her. And at 8 years old, she said the tub was on the left, shower tub was on the left, and the door was on the right. So we got a picture of the bathroom, and she's accurate. It's the scene where the crime happened. In this particular case, I mention it specifically because this is that house. They did not live there anymore. This report came to us a couple of years delayed, and so when it did come to us, we just went out to that house. The investigator went out, knocked on the doors very politely. Hey, some crimes happened here a while back, some kids were hurt, I was wondering if I could just take pictures of the house. We've done this a lot. I encourage you to stay on your investigators to get out into these homes, even when it's not the current residents of concern. And so far we've never been turned down. Nobody's ever said, no, you can't come in. They're very cooperative and it works great. But we got to have the crime scene identified. The reason why you do that, I kind of, in my mind, there's I'm sure more, but that part of the disclosure was accurate. It's a great thing to be able to show the jury that this child, no matter how old, teenager or little kid, they're accurate. They've described where this happened accurately. It's consistent with the nature of the assault. So we were talking about the couch, for example. The couch was consistent with the girl saying we couch surfing and stayed on that couch that night. And here's how he assaulted me by digital penetration. It could happen. I think it helps the jury see it through the child's eyes too, as they've described what happened to them to a jury, and then they get to see these pictures that the investigators found. I think it helps them see it through the kid's eyes. So the crime scene, there always is one. You've got to find it. Oftentimes multiple crime scenes, and get something to show what that crime scene looked like. Okay, the next area. This is my phrase. I'm sure there's some fans out there, but the opportunity evidence. And by that I mean, who do we have that puts the suspect and the child together? What evidence can we gather that they were together alone? These are crimes of secrecy. We put them together alone. Can we put them together alone at the location of the assault? For example, this couch I mentioned, the apartment renter was a lady who had let the suspect couch surf on her couch, and the one night that he had babysitting, so to speak, responsibilities for this little girl, she says she came around this corner to find them on the couch exactly as the child described, and saw the suspect make these furtive movements with his hands and pretend to be asleep. This was her view. So there's someone who gives us the opportunity for them to be together alone at the place the child said she was assaulted. Another example, a long delayed disclosure when the girl was 13 years old. Later she disclosed when she was 13 years old that she had administered oral sex to this much older man, and her 14-year-old friend's the one that drove her there. And so we have a 14-year-old friend who says that she drove her to meet this older man. Her friend got out of the car, got in the vehicle with the older man, and left. And then an hour later she came to her up, and 13-year-old friend got in the car with her and disclosed to her that he had had her perform oral sex on him. So we actually have a combination of things there, of course. We have a disclosure process and a delayed disclosure. And I just used Google Earth at trial and made a picture of that area, and this girl, 14-year-old, what then 14-year-old, now an adult, described, yeah, we drove up this road, parked in this parking lot. That's where he got in. I'm sorry, she got out and got in his truck. And then an hour came back, and I pulled in this parking lot and picked her up. So again, we have someone who puts them with that opportunity. This is an invoice, because it doesn't have to be people. This is where the girl said she went with the mechanic who worked for her financially, and at 8 years old he said, hey, let's go to the parts store. And so they jumped in the company truck and ran to the parts store. And on the way to the parts store, he felt free to put his hand down her underwear. So we went to the parts store and did this account, have the defendant show up, and sure enough, at the date and time she said they went to the parts store, the signature at the bottom is that suspect at the parts store. So simple things that show that opportunity to be together alone. Look for things, what brought them together, why were they together, what records do we have, be it digital records or old-fashioned things, photos, calendars. We had a case in which on a camping trip, and Grandma had noted the camping trip on the family calendar hanging on the wall there. Those sorts of things. Law enforcement reports. This case I mentioned here with the girl on the couch, that guy wouldn't leave the couch surfing situation, and so ultimately later that week this apartment resident called the local police and had him, as we call it here, trespassed, or told, leave and don't come back or you're going to be trespassing from this apartment. And of course we had a police report of that, which is consistent with the time and events going on that the child described when she was there. So we have him on the couch by not only the apartment dweller, but also by the police who came to kick him out. So simple things like that, we just look for receipts. Cell phones, of course, are great for showing that opportunity to be together and commit the crimes. Jump into the next area. We'll just buzz through real quick on tangible evidence. If this child has described it anywhere in their disclosure, their forensic interview, I want that seized with a search warrant. Anything tangible, everything that they could use or describe with any of their sensory perceptions. So simple, common ones. Children actually disclose that their stepdad sits in the chair naked while young girls on his computer, and does this regularly, does it a lot. They also disclose that he's sexually molested them. So of course that one's a softball, and we do a search warrant to include looking for pornography. And he drives a big rig, and in his big rig that he has on the road, we find pornography that is quote-unquote legal pornography, but at the same time it is of the genre of the young, well, just like his stepchildren. But just simple stuff. So when this girl says, yeah, he looks at young girls on the computer naked, now we have some corroboration, independent, that in fact she's accurate, she's reporting it accurate, and what she's seen is accurate. A young girl who says that when she goes for her visitation to dad, he uses medicine and makes her feel sleepy. And while she's used medicine, he uses a flashlight to inspect her or check her private parts. That's what she understood. And so we, of course, in that search, we grabbed the medicine that she described, and we grabbed her flashlight, as well as the other things that she described. But just examples that they are describing things and we're grabbing them. So there's tangible things. Doesn't necessarily mean the child was molested. It means they accurately reported what was there. This is a great time to have your multidisciplinary team, whatever group you have in your jurisdiction, to go through that interview items to as well as the things like this crime scene such we're talking about. It's a great opportunity for the multidisciplinary team. Let's jump to the next issue, victim issues. So victim issues come about because they're counterintuitive, and we have an obligation to, first of all, learn and understand that counterintuitive behaviors are normal. That's normal behavior for our victims. And we have to help the jury understand that. It may be using an expert witness in victimology. Maybe your forensic interviewer has those kind of qualifications. There's other personnel at your child advocacy center where you're reaching out to other people that can help the jury, help us help the jury understand that these counterintuitive behaviors by victims are normal for victims. The types of things we're talking about, excuse me, maybe the easiest for us who work in the field to grasp. We get very used to the delayed disclosure. It may be hours later, it may be years later. It is very counterintuitive to adults who don't know anything about this, and so when they're sitting on a jury, we have to explain it to a jury. We have to help them understand that delay is normal. That's what kids do. They don't run right out and tell. That's the unusual situation. So for example, we had a large case here in 2014. The disclosures and the trial ended up being in 2015. The victims involved in that, we got disclosures related to this particular defendant, start with victims in 2014 who were 39, 33, 30, 27, 25, 18, 14, and 13. Some of our statute of limitations under our state law, but none of them except the 30 and the 33-year-old. They had each told one person. One was a friend, one was another adult, or a different adult. They'd each separately told one person who did nothing, of course. And so here we were all these years later. They were all 13 or 14 at the time that they were assaulted, and they'd grown all these years later to where they hadn't told anybody. They never did. Very, very common. We need the jury to understand that. During this particular trial, the defendant called some quote-unquote character witnesses, and two ladies, one of them age 36 and one of them age 44, one had a friendship and one had a dating relationship with him. Both of them proclaimed that they would know if he was assaulting girls because their antennae were up because they had been molested when they were young. And both of them I asked on the stand, don't ask questions you don't know the answer to, and I asked each of them who they told when they were little, who did they disclose to. Both of them said, I've never told anybody. The 36-year-old said, I didn't have anybody to tell, and she cried about disclosing it for the first time on the stand. The 44-year-old got mad at me in answering that question and said, I couldn't tell my mom, she couldn't handle it. And so kind of drove home with his own character witnesses this idea that delayed disclosure, non-disclosure is very, very normal. So we need to be able to teach juries about that and have them understand. I mentioned this house before, and this is an example of delay where it's mixed because by the time this family had moved out of state, the uncle molesting the girls was discovered in kind of an inadvertent, accidental discovery that led to a semi-acute disclosure of the molestation out of state. During that disclosure, the child disclosed that it had been happening in my county too. And so that's why we came back to this house after they moved out of state, and we ultimately convicted him of those sexual assaults of his niece. The process of disclosure, we talked about that before, but it comes into also this counterintuitive delay. They can be accidental, it can be prompted, it can be purposeful because they finally have had enough. They may piecemeal disclosure where they kind of test the water and they pull back, see how we react. They can use piecemeal as a diversion. I'll tell you about this a little bit, but I'm not telling you about the big bad stuff. They can use the I don't know or I don't remember, gee whiz, I just don't know what you're talking about. All those things are how disclosures come out. They come out in pieces and sometimes accidentally and such. And juries need to understand that that is normal behavior. May definitely run into the process of victimization. These may need expert testimony for people to understand this process, but there's victim selection. I always focus on vulnerability. What makes this particular child vulnerable in the process of being selected by this perpetrator? There's something that gave them that vulnerability, whether it was the relationship between the two of them, with the victim's family, the victim family being dysfunctional, and this particular perpetrator took advantage of that. Whatever it is, there's something that made this vulnerable, and we look for evidence of it and we show it to the jury. Their next step of process of victimization is the engagement. They have to engage with the child. Sometimes that's kind of already started because of the prior relationship. Sometimes they have to go to great lengths to engage with the victim. There's grooming behavior. There's a huge list, just kind of ideas, suggestive sexual conduct, where they start crossing that line. They try to control the victims. They use drugs, alcohol. They use gifts. They use all kinds of different ways of grooming. Compliments, everything you can think of. There's the actual assault, and then there's the concealment of that assault. The concealment can be straight up. We see that. It can also be things like drugs and alcohol can help with concealment. In general, concealment happens most often by way of what's called shared responsibility, that the victim is made to feel somehow that they're sharing responsibility for this, they're a part of it, they're responsible, those sorts of things. And we may have to explain to the jury, why wouldn't they send to the or why wouldn't they tell, why wouldn't they run and get help? They thought it was their fault. They've been drinking and drugging, whatever the situation is. We may need someone to come in and help them understand that, and to do that we have to gather the evidence of this stuff happening. Memory issues, certainly have to become familiar with them, have experts if necessary help you. For instance, episodic versus script memory, that is single event versus long-term abuse, how they talk about the abuse. They have to have someone help the jury understand why a child talks in the way they do about long-term abuse. If you get into script memory, forensic interviewing training is great for that. Trauma has an effect on memory. This idea of fight, flight, or freeze is very real, and it has a very big effect on memory. When you combine the assault with drugs and alcohol, there's other things that happen. It changes perception, of course. There's a thing called peripheral sequencing that you would need to be familiar with if you have a case that involves the use of drugs or alcohol, where the peripheral details tend to be fuzzy, not there, forgotten, those sort of things. But the very central core details are extremely clear, where they will say things like, "I will never forget that." I had testimony last summer in which the very, very impaired female said, "I will never forget the sound of his belt buckle. I knew what was going to happen then." And just those very simple core details, the long-term coding of that memory. So this type of stuff we need experts to help us with. Another area of counterintuitive behavior is the recantation. And don't forget, the recantation idea is the taking back of a true allegation. There's numerous reasons why kids recant. There's huge family disruption when they disclose, the fear of testifying, shame, there's peer pressure, the knowledge that their friends at school or their friends at daycare, whatever it is, know about what's going on. Even if they don't know about it, there's still this feeling that everybody knows. All these pressures are on, and it's up to us to say, where is that pressure coming from? Identify that pressure, get evidence of it, and ask the question, what is this child trying to accomplish? What are they trying to accomplish? Taking back that allegation? Are they trying to reunify the family? What are they trying to do? So the 13-year-old that started that long list of disclosures I mentioned, had included a 39-year-old, 33-year-old, that whole list. That started with a 13-year-old. The 13-year-old was the first one to disclose. After disclosure, several things happened, including her family moved her to a whole new town in our county still, new school and all that. Get her out of there. This girl then ends up befriending a boy in class. This is then 9th grade by this time. That boy, of course, has a mother. That mother's meets this girl and befriends her. Come to find out, mother's married to the boy's stepfather, who just happens to be the best friend of our. So then, unbeknownst to us, boy's mom makes friends with the girl. One day goes and scoops the girl up and takes her over to meet with the defense attorney, where she does a recorded, nothing happened, I just made it up type thing. When she came to see me after that, she was embarrassed and all that, and I just played it straight up, just what's going on? And the very first thing she said to me was this phrase, "Am I in trouble for the second lie?" And it took a while to get through what that statement meant, but it meant, am I in trouble for recanting when the recantation wasn't true? And we talked for a while and assured her she was afraid she was getting arrested for having lied and so forth. And once we got past that and I got her to kind of relax and start talking, she said this phrase to me, "I just wanted it to be over." And that's how she said it too. That was the pressure on her. She just had incredible pressure between a dysfunctional family and the school. Everyone at this new school knew, and so on, and she just wanted it to be over. Recantation is a real thing. We have to be prepared for it. We have to be able to handle it. It doesn't blow the case out of the water. We have to look at real or not and be able to explain it to the jury. Kind of one last thing that kind of fits in these counterintuitive behaviors, and that is we always have to consider as an alternative that an allegation is a malicious false allegation. However, we know that research shows certain things. Teenagers typically do a malicious false allegation in three circumstances. One of it is to cover up consensual activity, so they get caught. But the interesting thing there is the research shows that when they do that, they'll almost always accuse a stranger. They don't accuse the person close to them to cover up their consensual activity. So we can have that explained to the jury. That's not, when they're accused of that, that's not what teens do. It may happen when there's a change in living situation. It doesn't mean that that's a malicious false allegation, but sometimes when the separation or divorce happens, it actually gives the teen or the child the freedom to then disclose where they couldn't before in the prior living situation. But you got to look at it. And then the research says serious mental health issues. So when we can cancel those out, it's helpful to be able to explain to a jury this idea of a malicious false allegation sounds sexy, but it's not. Young children, research shows, tends to circle around custody issues. And if you've heard young children try to give a coach disclosure or something, those kind of jump out very blatantly. So don't forget to look at these counterintuitive behaviors, see where they happened in the case you have, and be prepared to explain them so they make sense and the jury understands that these counterintuitive behaviors are normal. Another related issue is our victims are impacted by the horrific, and they you can see that in different things, behavioral things. And I throw a list out here of different things: sexually acting out, regression and pseudo-maturity, grooming habits. Why does the girl suddenly try to be as disgusting as possible? Maybe it's because she's trying to not be attractive to the perpetrator. It shows up in eating problems, post-traumatic type things, self-harm. All those things can be, it didn't happen before, now it's happening. Perhaps the sexual assault is the triggering event. We can see that in cognitive things, school-related problems. The one I mentioned to you with the long list, with the recantation, all those issues, the 14-year-old in that particular case. The mom related to us that after, what we knew is after the assault, the 14-year-old would not go to class if it was a male teacher. She started, a very extrovert girl became a big introvert and refused to attend classes with a male teacher, and the mom chalked, maybe she's going through puberty and so forth. Of course, when the disclosures come out a few months later, we're then able to put it all together, but this was a very definitive thing. There was the assault during the summer, and when she returns to school, she doesn't, I'm sorry, assault by this 43-year-old male. When she returns to school, she doesn't want to be taught by males. No surprise to us. We need to explain that and lay that out there as one of the things that happens. We end up with other cognitive issues, distorted self-image. They can struggle in school and other ways with the problem-solving skills and so forth. They can have emotional issues between depression. Dissociation is something that we've got to understand and be able to explain to a jury how kids dissociate during trauma. They can have post-traumatic responses, unusual, excessive fears, these types of things. There's some good talk about this in the APRI book, the Investigation and Prosecution of Child Abuse book. I have the reference here. I have the 3rd edition reference because that's what I have in my office. I know there's now a 4th edition, but that's a good list in that particular publication. But our issue is, how are we going to show that? We got to find it first in the investigation, and then we got to show it to the jury. And so look for the witnesses, look for the people who spend time with the child or around the child. Every case is different. And so we got to look for who is in that pool of people that are significant to this child that can talk about how they were pre-assault and post-assault, what their life was like, what their conduct was like, what their cognitive skills are like, and so forth. And then we may or may not need in this area an expert witness to explain it. That depends on the situation. If it's more like the counterintuitive behaviors, we may need a victimology expert. It may not if it's simple, straightforward things. I did not use an expert to try to explain, for example, why this girl would not want to be in a class with male teachers. I think that's something the jury sees. But you have to make that call. But the key is finding it, find what witnesses can see it, and then how do we tell the jury about it. Okay, the next I want to jump to is the medical evidence. And in the medical evidence, we have another one of those areas where we get a lot of people saying things that are inaccurate. This is a case with no medical evidence. And I will call them on that, and I'll call you on it every time. You always have medical evidence. It's either there's physical findings or there's no physical findings, which is about 90-95% of the cases. We know that. But to say the absence of physical findings is not medical evidence is absolutely wrong. We need to find out what that medical evidence is and deal with it. And normally we have to explain to, or usually we have to explain to a jury that it's normal to be normal. It's normal to have no physical findings. But that is medical evidence. We've got to deal with it. 3 quick points here. First, we have to show the jury that the medical evidence is consistent with the disclosure. Typically that means that the no evidence injury is actually expected in this case. And we can have the medical person, be it the examiner, a physician, whether you use an expert, use the one that actually did the examination. In most cases, that's expected because of, for example, the type of assault. Digital penetration, for example, we do not expect that to leave horrific scarring and injuries and such. Oral sex. I don't know how many times I've heard defendants try to use that. There's no physical evidence. You know, a delayed disclosure of oral sex, we don't expect it to leave injury and DNA months later, let alone weeks or days later. It's just not common sense. It's not the way it works in medicine, so we can explain that to them. Contact with the penis, for example, where the sexual assault is the perpetrator has the victim masturbate him. We don't have medical findings. We have medical evidence that, in fact, is consistent with the disclosure. The other one is healing. And the most common one there is when we have anal assaults. We have juries, lay people and such that expect horrific injuries with anal assaults when, in fact, the medical evidence is exactly the opposite. Your medical experts will tell you, unless it is really acute, in which case you may see some minor injuries, you won't find any evidence of injury from an anal assault. There's an area that is highly vascularized, it heals well, and it's designed to pass objects. And so it's an area the jury expects one thing, and we have to teach them that, in fact, that's what we should expect, is no evidence of that injury. Second area, the disclosures of the child that involve pain. They don't usually use the word pain, but they'll say things like it hurt, it didn't feel good, it was owie. Little kids, we've had them say, stuck me with a knife. Well, we know it wasn't a knife. We know they're trying to describe pain. And the importance of that, to understand and teach the importance of that to a jury, we have to understand. Then we have to teach the jury about the anatomy. So, for example, with a young female victim, we have to be able to point to the various anatomical structures that go from the outside, so to speak, the labia majora, through the labia minora, the vestibule, in other words, what's in front of the vagina, the fossa navicularis, the floor of that area, and the hymen, all before they get to the vagina, of course, and then dispel myths about the hymen. The hymen is not a piece of cellophane that just disappears. So we got to teach them about all that to get to the punchline, which is when kids are touched in the sense of you touch skin, it doesn't normally hurt, or it's not described as pain. When you get closer to the hymen, as you go through those anatomical structures, the sensitivity and the pain levels go up. And so what we can actually do is we can use that medical testimony to show that what the child's disclosing is actually evidence of penetration. So we not only are showing that it's consistent with the disclosure, we can use that evidence, the medical evidence, to show the significance of the pain, perhaps as evidence of penetration, depending on what the child says, but also we have the legal standard of vulva. Most states, or many states, it seems like, talk about some type of penetration of the vulva, some phrase like any penetration, however slight, of the vulva, the anus, etc. But using that phrase vulva, and we have to teach, we have to equate by teaching the jury that the vulva is the labia majora. It's the outermost structure. When we're talking about penetration, we don't have to have deep penetration. But penetration of the labia majora typically is what most state laws, check your state of course, there's my disclaimer, most states require penetration of the vulva, so we're talking about the labia. We need to teach that to a jury. Last area I want to talk about is as we get more sophisticated investigators in our preparation, we start looking at what's the defendant going to say, and we have to consider that there could be other explanations, or what the professional fancy people would call alternative hypotheses, for what the child is disclosing. We know the defendant's going to say that, and so we need to gather whatever evidence we can to first say, in fact, we have explored these alternative possibilities, and gather whatever evidence we need to show that they're not true, that what the child's saying is true and the defendant's claim is not. They generally fall into, mentioned by the top three here, and that is, of course, coaching. This child's being coached. To prepare to rebut that, we're going to look for types of things like sensory information. In the disclosure, is there things like description of genitals, information from all the different senses. When you have a true disclosure, you typically get much richer and deeper detailed information than those of you who've seen a coached disclosure where it's very surface, single important fact, keeps getting repeated, these sort of things. It just sounds very different. This stuff may come from the forensic interview. It may come from other sources too. Is the child using developmentally appropriate language, or are they parroting things that somebody has told them, given their age? If the child describes in their interview or at other times how they feel about the perpetrator, and they can articulate that, that sometimes can be very important as we look at if they're being coached or not. If they can talk about what they think about things, what they think about the perpetrator, what they think about the act, what they think about that location, these sort of things. They can be very, very helpful in rebutting this idea that somehow they're being coached. Another anticipated defense, somebody else did it, or the old some other dude did it, Saudi defense. We have to ask and we have to find out, for example, who had access to the child. And it could be babysitters, daycare providers. You know, there's family, there's boyfriends or girlfriends. Who else? Find out what that list is. And what we do is we narrow the field and eliminate everybody who did not have access. And by access, of course, we mean access alone, particularly at the place, at the crime scene that the child disclosed. And when you do that, you typically find that this list gets very, very small. It gets really narrowed down. And when we can narrow that field, who's been alone with the child at that location, that's very helpful in rebutting this idea that some random person did this. And then, of course, the standard mantra is that the kid is just lying. We got to explore all kinds of things. Most of them are common sense responses in looking at that. So look at things like, what's the child's motive to lie? What was their relationship with the offender? And you're going to find there's some sort of relationship typically. They're typically not molested by or assaulted by strangers. Look at the time that they spent together. What type of activities, was it, what kind of quality relationship, and then look at what's changed before the assaults, after the assaults, before the disclosure, after the disclosure, and you typically can see those changes happening consistent with the process of the disclosure, as opposed to somehow just made it up out of the blue. It's interesting oftentimes to find out how the child does feel about the offender now. You know, there's the old thing that kids very, very often still love their offender. It's a relationship that they can't quite understand the assaultive behavior, but they love the offender. And so we get into a real difficult thing for jurors to understand. We got to help them understand and explain that to them. Question I like to ask is, how does this particular child act when they're mad or when they're in trouble? You can talk to teachers about that, daycare providers, family, grandparents, whatever is appropriate in the given case. But how does this child act out when they're mad? Do they hurl around accusations of sexual misconduct? And you're going to find most often not. That's not how they act when they get mad. They stomp and throw a temper tantrum or whatever, but a clear and concise disclosure of sexual molestation is not a temper tantrum, and we have to get away from that. The other one to think about is the teenage. Typically, the teenager brings a world of hurt down on themselves when they make a disclosure. There's family disruption. There's all those things we talked about, for example, in the recantation pressures with peers knowing what's going on, what they perceive as humiliation and so forth. They bring the world of hurt on themselves. And you have to ask, why would they do that? So you're going to say that they're lying about this and they're self-inflicting this kind of world of hurt on themselves. It kind of falls apart. Just that common sense response oftentimes will help this one just fall apart. So I know that was fast and rapid. I'm talking kind of fast here, but we've been through the process of disclosure and all those prior consistent statements. Help show the child is not just randomly out of the blue making this up, but there's typically a really, really compelling story there. The crime scene, we have to be able to show where it happened. It's consistent with the child's disclosure. The opportunity, in fact, does present itself for these two to be alone in the place of the crime, for example, or whatever opportunity is necessary, consistent with the disclosure. Tangible evidence from the crime scenes, from other places, however it is that, whatever it is, I mean, that they disclose in their interview, for example, be it places at the crime scene, things used as grooming tools, whatever it is. Victim issues, talked about the counterintuitive behaviors. We need to not only identify those, get evidence of, then be able to explain them to a jury. The changes in behaviors for the victim, same thing. Be able to identify them and explain them to a jury. Medical evidence, never, never, never let your folks get away with saying there is no medical evidence, because there's always going to be medical evidence, and if you haven't had an examination, have one so you can say there's no physical findings and why that's consistent. But we got to stay with why it's consistent, and of course it may help us with evidence of penetration when it comes to especially younger children, trying to describe penetration, because that's a horrific thing to try to expect of that child. And then be thinking bigger picture, what's this defendant going to say? Even when they've maintained their right to remain silent, we know they're going to say something through their attorney at trial along the lines of, someone else did it, this kid's lying, they've been coached, and we need to be ready for that. And the time to get ready for that is not when you're ready to do rebuttal evidence in trial. We need to do that as part of the investigation, part of our trial preparation. Okay, so I think I turn it back over to Amy now, if Amy's there.
Yeah, I'm here. Sorry.
Excellent.
A few questions. Let's see. What are some indications of a coerced disclosure, and what makes them blatant in appearance?
That broke up just a little bit. Indications of a coerced?
A coerced disclosure.
Oh, coerced disclosure. Sorry. Okay.
And what makes them blatant in appearance?
Okay. So when I guess when I say that we're coercive, I'm thinking of like the coached ones where maybe mom grabs the kid and says, go in there and tell them, Daddy, you touched your pee-pee, or something like that. What you see is the child can't come up with tactile details, can't keep it coherent, consistent. They've been told to say A, B, and C, and what they can say is A, B, and C. They can't give you details from a perspective as somebody who's actually experienced that. So you could be told about what it's like to stand on the lip of the Grand Canyon. And you could repeat that to me, but if you've been there and stood there and looked at the Grand Canyon, your description is going to be much richer, much more full of details, little details that somebody else may not have noticed that you notice, those sorts of things. And it's the same way when they give a very canned disclosure that, say a parent said, go in and tell them this, that sort of thing. It's very, very, for lack of a better term, I'm thinking of the word shallow. It's very thin and shallow as opposed to having some details that show that they experienced this and they can talk about it in different ways, not just repeat the same kind of mantra over and over.
Okay. Wow, they're coming in. Lots of questions. Let's do. What kind of experts would you speak to the issues of victim issues and changes in behaviors, like social worker or child behaviorist or a psychologist? Are there any other people that you would talk to?
Those are good ones. What you're going to find is people that work in the area of child abuse is probably the first thing you need to look at. Typically that would be someone with not only advanced education in the sense of either psychologist or someone with advanced degrees in social work, but their experience is working with a lot of kids who've been abused, kids who haven't been abused, so they have some contrast. And in your communities throughout the nation, there's a number of people who have become well-versed in these victimology issues. And they can come in and they can say, not only is my training back it up, the research backs it up, and then my experience backs it up, and even though it's not intuitive to us as an adult, here's how a kid acts when blank, whichever one it is, delaying disclosure or their desire to take the pressure off by recanting or whatever that counterintuitive behavior is. They are able to explain that, but it's really kind of sifting through who's around, looking nationally, contacting the folks at APA, contacting me, the people that can maybe refer you to others. I've brought a couple in from out of state for my trials, as well as there's a few around in my state that I've worked with that I'm comfortable saying, hey, can you explain why kids delay in disclosing, and that it's normal, and those sort of things, if that hits the question.
Okay, and we have time for one more question.
One more.
Yeah. Anecdotally, in your career, how often have you had a false disclosure?
I got all the way up to the end of the question. How often have I had, what was it?
A false disclosure.
False disclosure. Good question. Very, very infrequent. They occur occasionally, and like I say, we don't end up at trial where we suddenly smack ourselves on the forehead and say, oh my gosh, we're dealing with a malicious false disclosure, because it's during that process of the forensic interview, oftentimes even at that level, the investigator, the prosecutor, whoever's observing it, all the people observing it, your eyebrows are kind of raised, and you're like, something doesn't add up here. And then as the investigation continues, you find that things just aren't adding up. And we don't often prove, so to speak, quote unquote, I use air quotes, prove that it was a false disclosure, but we can't bring it home that everything adds up. We had one a while back where we actually charged a young lady because she tried to carry off a backseat of this car, and it all fell apart, and it can't come to find out it was involving dealing drugs in the backseat of the car, and she was getting caught, and so she just publicly blasted this other young man who had no relationship to it. You don't normally have it quite that clear. It's just things don't add up. So anecdotally, it's pretty infrequent, and they don't go very far, I guess, is probably the more important point. Good question, though.
Great. Thank you, Bill, for an excellent and very informative presentation. And thank you to our webinar audience in attendance. All of the APA webinar materials and recordings are available at no cost on our APA membership website, and we will be notifying you via email when these materials become available and how you can access them through a temporary membership. If you are a current APA prosecutor, court, law enforcement, or criminal justice partners member, you will have automatic access to webinar materials once they are available online. If you have any questions or concerns, please email us at webinars@apainc.org. Thank you for attending, and please don't forget to fill out the survey evaluation that will be emailed to you after this webinar. Thank you, and have a great day.